Hello, everyone. Welcome to the National Constitution Center. See that we're still filing a little bit. It's great to see such a full crowd. For those of you who don't know me, my name's Tom Donnelly. I'm the National Constitution Center's Senior Fellow for Constitutional Studies. I want to thank you so much for coming to this, which should be an extraordinary event on the Supreme Court in transition. First, just a few items, housekeeping items. First, we will be during the program, we'll be passing out note cards to all of you in the audience. If you have questions for our panelists, please just write them down. We'll collect them, and with about 20 minutes left in the program, I'll get them, and we'll try to cycle through as many audience questions as we can. After the program, we're going to have a special book sale and signing opportunity with Lincoln Caplan, and we'll be discussing his terrific new book, American Justice 2016, The Political Supreme Court, as part of this panel. But he'll be downstairs in the main lobby for a book sale and signing. There's also a special tour of Signers Hall and Constituting Liberty for members and their guests at 1:30 following that book signing, so there's that opportunity too. And I'd just like to thank for all the members out there, thank you so much for joining us today. If anyone's interested in information about membership at the National Constitution Center, visit the members table outside of the theater. I think those are the main logistical items. Now let me introduce our extraordinary panel, and we really couldn't have a better group of three people to discuss the Supreme Court at this pivotal time in the heart of an important election. First, we have Lincoln Caplan, is a senior research scholar and a visiting lecturer at Yale Law School. He's the author of, as I said, American Justice 2016, The Political Supreme Court. He wrote about the Supreme Court as a staff writer for The New Yorker and as a member of the editorial board of The New York Times. And he really is just one of the leading observers of the Supreme Court and legal commentators in the country. We also have Robert Barnes. He has been a Washington Post reporter and editor since 1987, and he is their primary correspondent following the Supreme Court. And then finally, we have Marcia Coyle, who is the chief correspondent for the National Law Journal, which is a national weekly newspaper covering the intersection of law and policy. She's a lawyer and a journalist, and she's also a regular contributor of the Supreme Court analysis on the PBS NewsHour, where she is absolutely terrific. Always one of my favorite segments when she's on talking about the Supreme Court. She's also the author of a book from a couple of years ago called The Roberts Court, The Struggle for the Constitution, which is also superb and I highly recommend. So please give a warm National Constitution Center hand to Robert Barnes, Lincoln Caplan, and Marcia Coyle.
Thank you.
Oh, of course. Well, again, thank you so much for being here. And as we all know, we're in the heart of a presidential election where the Supreme Court, all sides, it seems like both sides disagree on just about everything, but they do agree on the fact that this election matters a lot for the Supreme Court. So it's a great time to talk about the 4-4 court that we have right now and the Supreme Court in transition as we head towards the election. But I'd like to begin with you, Link. You've authored this book, American Justice 2016, The Political Supreme Court. Do you want to just maybe set the stage by telling us what was your impetus behind writing this book?
So the impetus belongs to the University of Pennsylvania Press. 2 years ago, they began a series. The first one was done by Garrett Epps, who covers the court for The Atlantic and is also a con law scholar and a professor of constitutional law. And when I was asked last fall if I was interested in proposing a book in the series, I said that I had always wanted to read a body of political science about the court that I was aware of but hadn't really delved into, and that I was interested in the court as a political institution. Was that anywhere near an interesting topic? And I wrote up my proposal, and by February it looked like my crystal ball was working. And when Justice Scalia died, all of a sudden everybody was talking about the Supreme Court the way political scientists do. So they focus on results. They're not all that interested in what legal scholars and lawyers focus on and what my very distinguished colleagues do in their reporting, which is how courts decide, how this court decides, and as well as where it ends up in terms of results. And the striking thing about what happened in the conversation about the court after Justice Scalia's death was that everybody in Washington was only focused on the results, and there was an immediate consensus, whether you were a conservative or a liberal, that whoever chose the ninth justice, whoever chose Justice Scalia's replacement, was going to determine the path of the court. Was it going to stay conservative and really partisan in a way the court has never been, making a majority of 5 Republican-appointed conservative justices, or was the court really for the first time in almost half a century going to have a majority that was moderate or moderate liberal? And that's the frame that makes this election so dramatic for the court. And it's thrilling to me, not just because of the opportunity I've had as a result of the Penn Press's series, but it's thrilling for me that for the first time in my lifetime, there's a serious conversation about the court in relation to the election.
Well, that's terrific. Now, Marcia, just to bring you into the conversation, I mean, when Lincoln describes the court as a political court, to what degree do you think that's right or wrong, and sort of how do you view the court and how it tries to balance law versus politics?
Well, I think what I really liked about Link's book is that when I talk to groups, mostly non-legal groups, the question I get most often from them is the court practicing law or is it practicing politics? And then I have to think, okay, now do you mean politics in the partisan sense or politics in terms of it being a political institution? And we all tend to look at court decisions as, is it a win for the liberals or the conservatives, or a loss for the liberals or the conservatives? And we don't really place the court where it is in the structure of our government, because it is a political institution. It's part of the government. The justices are nominated by a president, and that president is going to nominate someone who, if he or she doesn't know how that person may ultimately decide cases, at least has a sense that that person shares a similar political philosophy or approach to the law. And then the process continues. That person who's nominated goes before the Senate and is then thrust into the political process in a way that he or she probably never has been before. Gets on the bench. This is not someone who takes up a case and writes on a clean slate. This is someone who's bringing to bear all of life's experiences in law, religion, everything. And so you just can't look at these justices or the court as simply a legal institution. So that's what I like so much about Link's book, because I think in a very clear way, he demonstrates how the court, this interplay between, or this sort of dual nature of the court as a legal and a political institution.
Now, Bob, you're coming to us from Washington, D.C. Where do you come down in sort of this question of the Supreme Court as political institution versus legal institution? And just to complicate it a little bit, one of the more famous decisions of the last 3 terms was Chief Justice Roberts sort of splitting the baby on NFIB with the Affordable Care Act case. And on the one hand, we have a Congress that votes in absolute partisan terms on that issue, and yet in NFIB and then even in King versus Burwell, we have essentially the Chief Justice, who was a Republican appointee, voting to uphold President Obama's main policy initiative. So how do you think about those sorts of decisions, and also just the larger question of law versus politics?
Well, I thought that was a fascinating decision, and what has happened as a result of it is equally fascinating. You saw during the Republican presidential debates that the Chief Justice was absolutely excoriated. I mean, this was a guy that was always held up to be the sort of epitome of what a nominee to the Supreme Court was supposed to be. You probably remember his famous, we're referees, we're umpires, we call balls and strikes, we're not players. And he has been a very conservative member of the court, just as President Bush would have hoped for, except for these 2 votes on Obamacare, basically. And instead of that being seen as someone who sort of calls them like he sees them, he was marked as basically a traitor during those debates, and a terrible mistake for President Bush to have made. And so I think that shows that everyone says they want a court that looks at these things with no bias and no background. But the fact is, presidents, it is their legacy, the people that they put on the court. We're now at the 25-year mark of Justice Thomas. If he continues to serve until age 80, he will be the longest serving justice in the history of the court. And so, this is what presidents are looking for when they make these nominations.
I really don't know what's in the mind of each justice when he or she sits down to write a decision. And yet I think sometimes we have to step back and think about how we look at the court and what is influencing our view of the court. Certainly in the last couple years, there's been such a hyper-partisan nature about government. In Congress, it infects everything. So I think it has also infected how we view the court. And just what Bob said about Roberts, for example. I was really stunned when the chairman of the Senate Judiciary Committee, Charles Grassley, took to the floor and reamed Roberts for all the problems that we have, blamed him for Obama, everything. And then an ad comes out right before the election from a conservative group that says, no more mistakes, and pictures Roberts, David Souter, Anthony Kennedy. And I was thinking, oh my gosh, what is happening to us? Because as Bob said, Roberts is somebody who the conservatives really should be very proud of for the most part.
So one of the most important concepts for people who watch the court and think about the court and how it's doing is its legitimacy. And the ultimate test of any theory of judging or of how a justice is doing and affecting the character and the reputation of the court is what the effect is on the court's legitimacy. And a fascinating aspect of the reporting I did for this book is that there is no good measure of legitimacy. So it's one of the reasons why when the Republicans are even more critical of Roberts than the Democrats, there's no easy way to respond except to say that the Republicans' disappointment with Roberts is a measure of how much they've expected the court to be the Republican court, which is what Lee Epstein, one of the leading political scientists who follows the court, has called it. Her view is that we're now in the 48th year of the Republican court, and that really frames this what will happen in the presidential election. And this is something that Jeff Rosen has written very well about, but it also means that the reporting that people do about cases has to include not just where the court came out, but how we measure who's satisfied by that. Not whether the winning or losing party responds, but also how the rest of us as citizens think about that as an expression of the meaning of the Constitution or a particular statute. And it was just absolutely fascinating to me that there is no agreed on measure of legitimacy, which is at the center of any assessment of the court.
No, absolutely. Now, returning to you, Bob, now, obviously we had Justice Scalia's untimely death earlier this year, and we've now had, towards the end of last term, some experience with the 4-4 Roberts Court, and now we've just started the new term with, again, a 4-4, or at least an 8-justice court with 4 Republican appointees and 4 Democratic appointees. What do you think, what have we learned about where the Roberts Court is now more than a decade into Chief Justice Roberts' tenure from sort of the experience of that 8-justice court? And what might it suggest about, what the future might hold?
Well, I think it does show that it is a court very much on the edge on important issues. I mean, one thing that you always have to keep in mind is that not all Supreme Court cases weigh the same or should weigh the same. And sometimes one of the criticisms I have of political scientists looking at the court is that they have to judge every case as a liberal, a liberal side and a conservative side, and then you sort of add them up, when in fact some are much more important than other ones. But we do have, on very important cases, a real ideological split, 4-4, In many cases, one of the four conservatives, Justice Kennedy, often sides with the liberals on some social issues. And so in a way, someone I thought smartly said not long ago, we already have a liberal majority on the court on some issues, same-sex marriage, for instance. I think gay rights is one of those areas in which there's already a liberal majority. But you see it play out all the time, and I think the sort of best example of that is that currently is that the court took 3 cases before Justice Scalia died he died last February. They took 3 cases in January, one of which involves a church and raises some interesting church and state questions. After all this time, the court still has not scheduled those cases for oral argument. And so you get the feeling that the court must be waiting for a 9th justice, or in hopes that there's going to be a 9th justice, because they don't want to take up a case that they already know they're split 4-4 on. And they would know that from their discussion at the time about whether to take the case. And so these cases sort of hang out there, and it seems quite clear that they're waiting for a 9th justice, or hopes that there will be a 9th justice to break the tie.
I also think as you watch the court going forward this term with 8 justices, that we're going to see again a little bit of what we saw last term after Justice Scalia's death. And that is that there is a sort of a core group of justices on the court who are trying very hard to reach consensus. It may mean narrow opinions. It may mean something as unusual as what we saw in the case involving religious nonprofits that were trying to, objecting to the government's accommodation of their objection to providing contraceptive health insurance. In that case, the court heard arguments, called for extra briefing, and suggested a compromise that it wanted the parties, the religious nonprofits and the Obama administration, to brief. And then after getting all the briefs in, the court decided, well, it seemed as though to the justices there was some room for compromise here, so we're going to send the cases, and there were 7 of them, I believe, all the way back to the lower courts and give them time to work out a compromise. And that was, it wasn't unprecedented, but it was very unusual that the court would do it. So I talk about this core group. So who are they? Who do you want to watch? I would watch, obviously, Justice Kennedy, who's often in the middle on a number of cases, but also Justices Kagan and Breyer. I think that trio really was responsible for some real consensus last term, some narrower opinions. And I think the Chief Justice as well will try to be in there when he can. Then you have, really on the ends, you have someone like Justices Alito and Thomas, who, you know, when they see an issue that they think is black and white, they're not going to move. And then on the other end, you probably see Justices Ginsburg and Sotomayor, who are similar in terms of how they may view an issue. So I think it's that core group in the middle that I mentioned that are really going to do a lot of the heavy lifting in the coming term.
My favorite part of that compromise was, as Marcia said, the court asked for additional briefing, and basically the way I read the briefs, they came back and one side said, well, yeah, we can compromise as long as we do it our way. And the government said, well, yeah, we can compromise as long as we do it our way. And the court said, good enough for us.
That's it.
Send it back.
Totally agree. We all read the briefs and thought, what?
And so, Link, what do you think of Marcia's sort of, laid out sort of like the ideological span of the current justices on the court? What do you think of her characterization of sort of where they sit, and then sort of projecting forward if we end up getting let's say a progressive replacement for Justice Scalia? To what degree do you think we're going to see sort of a radical shift in the law versus the possibility of some sort of maybe pragmatic core of the court at the court of maybe the Chief Justice, Justice Kennedy, Justice Kagan, and Justice Breyer?
So the most important thing to say is that there hasn't been a robust liberal on the court since Justices Brennan and Marshall stepped down. There are signs of real liberalism from all of the four who make up the Democratic appointed liberal justices, but each one of them is much more committed to the integrity of the legal process than a justice who would only be focused on a result, and that's a constraint for them. If Justice Garland emerges out of Chief Judge Garland, that is, if Merrick Garland is considered and appointed, he's a minimalist. He's been that way for 19, now in his 20th term on the DC Circuit, and he's likely to really focus on trying to build coalitions in exactly the way that Chief Justice Roberts talked about during his confirmation hearing, saying that he was going to seek unanimity. If, for whatever reason, either the left pushes hardest or the right does, depending on who's elected president, Garland doesn't become a justice, what happens to the court will depend on who the next president picks to fill that seat. It's a truism about the court that the whole thing changes every time there's a new member. But in this case, because we have an unprecedented historical situation where you've got this 4-4 split, and it's not just ideological, but it's perceived as partisan, this choice seems to be particularly freighted. One of the most important conclusions I came to is that if I were czar of the universe, I would have a constitutional amendment that changed the terms of the Supreme Court justices. Rather than having lifetime appointments for good behavior, I would have each justice serve in good health and good behavior for 18 years. And what that would mean is that every 2 years, a new justice would be selected by a president, and the Senate would advise and consent and confirm or not. But likely you would have each president appoint 2 justices, and if a president's reelected, 4. And my sense is that that would change people's expectations of the Senate confirmation hearings. They would be more straightforwardly about policy and perhaps how a nominee might have voted on in past cases. But you would also take some of the heat out of the now very dramatic carnival-like atmosphere of those hearings, and they would be more straightforward about filling the bench. It seems to me that if we agree that the court is both a political and a legal institution, then that would take the intensity of focus and of investment of politics out of these choices and realign the court more as a legal institution and less as a self-consciously political one.
Marcia, what do you think about that particular proposal?
Well, first I'd like to go back to your original question, and
Sure.
then I'll
Of course.
talk about term limits. I think when I first started covering the court, the one thing I was taught was by my colleagues was the court moves incrementally. All right, so if there is suddenly a 5th justice for the left side of the court, what might happen? Well, I think even though every time there's a new justice, the court changes, I don't think this court, from what some of its members have said and written over time, want to change areas of the law quickly and dramatically, because then it does look like they're playing politics. It is a political it's more than just a political institution, it's a partisan institution. So I really don't think that you would see dramatic change quickly. And when you think about it, there really hasn't been that many really dramatic turns by the Supreme Court. I mean, you could look at Bush v. Gore as standing alone, but even Citizens United, if you take a step back, the court was coming step by step to Citizens United. Again, they don't write on a clean slate. So I think it would be a while before we saw any changes, and it would depend on the kinds of cases that came before them, whether there were long-standing precedents. I remember during the last presidential debate, Donald Trump saying, or responding to a question about who he would appoint to the Supreme Court, and he was saying, and he would appoint justices to overturn Roe v. Wade. And I was thinking, well, I wouldn't be too sure about that. Roe v. Wade's been around a long time, and then there was this other decision by the court in '93, Casey, in which the court reaffirmed Roe v. Wade, and the court looks, before it overturns an old precedent, it has certain guidelines. They're not binding, but it's very careful about doing that, and some of the justices care more about what we call stare decisis, standing by precedents, than others do. But I think what the real constraint on them would be not to immediately overturn cases that were very controversial or were 5-4 decisions, so that they don't look like they're playing politics. So that's my sense of what we might see if there's that kind of a change. Now, as far as term limits go, I don't have any strong feelings about that. I think the most positive thing that, and Link wrote very thoroughly about some proposals here, the 18-year term limit, I think really would de-escalate the hyper-partisanship that now surrounds Supreme Court confirmations. So I think that really has some merit. But what you want a term limit that's long enough that everybody believes that the new justice is insulated from outside forces, is not worrying about where his or her next job is coming from.
So Bob, just if you want to say anything on term limits, certainly do, but I also just wanted to put on the table, so we have this election coming up, we have the possibility of, one, there's the vacancy we already have, but the possibility of 2, 3 other ones. I think it's true that the court does, try to move relatively slowly, as Marcia just observed, but what are some of the areas in which we could see real shifts in sort of a Donald Trump court versus a Hillary Clinton court, if they have the opportunity to put a few additional nominees on the court? What are some of the areas of the law that we should be watching?
Well, one of the areas that certainly Donald Trump talks about a lot is the Second Amendment. Although, again, I'm like Marcia, I don't see any reason for the court to try to overturn the Heller decision, which established that there was an individual right to own a firearm. Since that decision, there haven't been any kinds of gun control that have, except one in Chicago, that was very similar, that have been overturned. The court has sort of proceeded. Lower courts have upheld gun control measures in a lot of places, and the court has refused to get involved to review those decisions. And so I guess I can come up with more areas where I don't think that there would be sort of tremendous change. I do think campaign finance is an area in which there is a real difference between the Democratic appointed justices and the Republican appointed justices. I don't know exactly how you would go about overturning Citizens United. I don't see a vehicle out there for that. But I do think that the court made up of Democratic appointed justices would be much more accepting of some areas of campaign finance change and regulation than the Republicans would. I think you could see the court trying to relax this idea that came up in Citizens United and elsewhere, that the only thing that the court looks at is whether it is a bribe, a quid pro quo, contribution for action. I think the court with the Democratic appointed justices in charge would be much more forgiving of legislatures trying to regulate campaign contributions.
So there are 3 areas where a Trump court, is my guess, would be very, very different from a Clinton court. The first one, which Bob focused on, is campaign finance. It's a liberal fantasy that Citizens United will be overturned. It won't, at least not anytime soon. But the election experts who are very intent on this issue say that there are likely to be two places where they will look to change the law. One of them has to do with reimposing an individual limit on contributions to super PACs. This is an issue that was decided by the DC Circuit but didn't get to the US Supreme Court. So a state could have a law imposing that kind of limit that would, in principle, not follow the result in the DC Circuit. And you could imagine another circuit upholding this reinstituted limit, and then the court eventually taking that case, and the Clinton and Trump courts very likely would deal differently. The second area is voting rights. Again, it's a liberal fantasy that the Shelby County opinion striking down the heart of the Voting Rights Act would be overturned. Not very likely, but the Voting Rights Act is a robust piece of law, and it's being challenged and really flouted to the extent that the New York Times is reporting almost daily about this. There are all kinds of ways that Republicans on the ground are trying to make it difficult for minorities and poor people in particular to register to vote. And they do it in the name of voter integrity and election integrity. But again, the Clinton and the Trump courts would likely deal very differently. And the last area that's obvious is the death penalty. At the end of 2015, Justice Breyer wrote a very important dissent in a case called Glossop v. Gross, which came out of Oklahoma, where he essentially called for a return to a consideration of the fundamental constitutionality of the death penalty. Justice Ginsburg joined that dissent, and it's absolutely clear that a Clinton court would be more eager to entertain that kind of reconsideration than a Trump court. And there are other areas as well, but those three are dramatic, and I think that the closer you look at the detail, the more you could predict different outcomes depending on who fills that ninth seat.
Sure. Marcia, anything on the Clinton versus Trump court?
Well, I think Link has picked out areas that we would see real differences. We might also see real differences in the areas of religion. I think that the conservative majority currently on the court, if it continues, is much more accommodating of government and religion, the mix. Government funding religion. It has shown how it views mandates that come from the government in the Health Care Act that might affect religions. Whereas I think if you have a liberal majority on the court, they're going to be much more skeptical of, I would say, the wall between church and state, except I don't think there's really much of a wall between church and state right now anyway. But I think that you would see religion as an area. One area where you might see them, sort of the same might be the area of the First Amendment, sort of the pure speech First Amendment. This is a court right now that is, with some minor exceptions, very protective of speech that we don't like, because that's, and political speech, which is at the core of the First Amendment. So I don't know that you'd see much difference there. But I think Link has hit the big ones. The death penalty is really interesting to watch right now, what's happening with it. Yes, Justice Breyer sort of laid down a gauntlet. Hey, look at all the problems we're having. And he laid them out one by one. I mean, it was amazing dissent that he wrote. So let's take another look at it. And then you have Justice Sotomayor, who really now, I think what she brings to the court is her trial judge experience. She is the only justice who has held trials, sentenced people to jail. So she's now looking and writing in dissents, in denials, when the court refuses to take death cases. If she sees a problem that she thought the court should have addressed, she's writing about it. A lawyer who was horrible, this is not right. This violates the Sixth Amendment. So she's picking the problems that Breyer identified in his dissent, and I think we're going to see a lot more from her as she does that.
And this one is really just for any and all of you. I mean, as we continue to watch the current term, is there a particular case or two that savvy court watchers should be looking at this term as sort of understand, either because of its legal importance or just to understand, what's happening at the Roberts Court more generally?
Bob, you want to try that one?
This is not the best term so far for picking a fantastic case.
Maybe a sleeper.
Yeah, I'm trying to think of what the sleeper is. I mean, it's this is very difficult, I think, to quantify. But I think all of us had the view since Justice Scalia's death and with the uncertainty over the court that the court has sort of stepped back a little bit in taking big cases that are going to be really controversial. And it's hard to find a case, I think, where you say, boy, they really should have taken that one. They sidestepped a big controversy. But at the same time, it just feels like the cases they are taking are much smaller bore and more limited questions. And that we won't see a real change in that until the court is at full strength. But am I forgetting?
No, I think you're absolutely right. It doesn't mean that they're not interesting cases that they've taken. It's just that we've become so accustomed in the last 11 years to almost every term having what we call a blockbuster that would be your headline news on the front page. And this term, we don't quite see one yet. So I think the court is not only worried about where a fifth vote might come on a controversial case, but also wants to keep a low profile because of the election. Just doesn't want to be any more of an issue than it already is, which is the nature of the court. Even the religion case that Bob had mentioned earlier about the church, there's a church that has brought a First Amendment challenge to the Supreme Court because the state of Missouri wouldn't allow it to participate in a grant program that is used by public schools to repave their playgrounds with recycled tires. And the Missouri Constitution has a provision prohibiting the state of Missouri from using state funds for religious-related projects. And in a way, that's really an old-fashioned case. We've seen different versions of that kind of case. It's not like the religious nonprofits trying to fight the government over what they should do with contraceptive health insurance. I mean, that's a little different. So I think it is a low-profile term so far. But like I said,
I should say one thing, and then I'll shut up so we can get questions. We'll have a quick test of this, I think, pretty soon. The court is considering whether to take up the case of a transgender student and whether or not he can use the bathroom at school and what public schools have to do. So we should find out about that quickly. And Texas and probably North Carolina will also be bringing to the court cases in which their voting regulations and restrictions have been struck down by the lower courts, and they will want the Supreme Court to take a look at those. And if the court decides to get involved in those cases, I think that will say something.
I agree. I think the voting rights cases are more important. Now, I'll tell you the transgender case, which is just, again, sort of reflective of this term, if they take it. It doesn't even go to the real big question about the rights of transgender individuals under our Constitution. It's a question, I've never even talked about this on the NewsHour, about something called our deference, and that's AUER. And it comes from an early Supreme Court decision that basically says, when federal courts are looking at an agency's guidance or regulation and the agency is giving its interpretation of an ambiguous regulation, federal courts should defer to the agency because federal courts don't have all the expertise that a lot of these agencies have. So that's exactly what the lower appellate court did in the transgender boys case. They deferred to the Department of Education and the Department of Justice, which had sent out letters to schools on how best to deal with the bathroom issue. And so the question that comes to the court is, really, should the lower court have deferred? So it's not even, it doesn't even go to the heart. But that kind of a case that raises the constitutional issue will come to the court. It's been raised by a number of states, Republican states, in Texas, and so it's going to eventually get to the court.
So I'm going to dissent.
Okay.
I think the case being argued on November 29th, called Moore v. Texas, is a really important death penalty case. If you read the papers in it, it's just overwhelmingly technical seeming. The question is whether the definition of intellectual disability, which used to be called mental retardation, that Texas uses, which is different from any other state, really a kind of amateur's invocation of a character out of Steinbeck as the model for intellectual disability, whether that's constitutional. And this is a window on the state that has executed 2 out of every 5 people who have been executed in the United States since 40 years ago when the Supreme Court reinstituted the death penalty. And it has enormous human consequences. Justice Kennedy has been the leader on the court of narrowing who the death penalty can be applied to. In 2002, in a case out of Virginia, the Atkins case, it said that people who are intellectually disabled don't have the moral capability and therefore the moral culpability to have a death sentence imposed on them and for them to be executed. And Texas managed to defy this rule in complicated ways, and the court's going to reckon with that at the end of November. And that's a potentially very important case about the death penalty, where the warring conceptions about its role in American criminal justice could surface. It also could be dealt with in a very narrow precedent because Texas is just an outlier. We'll find out.
Well, that's what I was going to say. I was going to say I sort of dissent because it's Texas. Yeah. It's the only one that would go to use John Steinbeck's book of Mice and Men to justify or to define intellectual disability. So you almost think the court looked at this and said, what? And took it so that it could reverse Texas. But certainly if they affirmed Texas, it would be amazing.
You can't dissent from the dissent. Go ahead.
No, wait, didn't somebody do that?
Well, excellent. We have some superb questions from the audience. We'll try to get through as many as we can, starting with a couple on the Garland nomination. So assume Clinton wins the presidency and the Democrats win the Senate. The Republicans filibuster Clinton's Supreme Court picks. Do you see the Democrats changing Senate rules to eliminate filibusters for all court picks? And relatedly, if Hillary wins, will the Senate approve Merrick Garland before she takes office?
Well, we were just talking about that, so Bob, go ahead.
Bob
you had
to
to
speak for all of us.
That's right, he will.
I would be, and you have to sort of, all of these scenarios have 2 or 3 parts to them, unfortunately, but if Secretary Clinton is elected, if there is a Democratic incoming Senate, then I think that they would get rid of the filibuster if there was serious opposition to her nominees. The answer to will the Republican Senate right now act in a lame duck session, I don't think anyone knows the answer to. And certainly I think it is the hopes of Democrats that you get an incoming Democratic Senate and a Democratic president, and the Republican Senate now says, let's go ahead and put Garland in because he's the best we're going to get. I personally would think that Secretary Clinton might even be happy with a scenario like that, so she doesn't start her term with a Supreme Court vacancy that she has to deal with right away. And, as we have discussed, we have an 83-year-old member of the court, an 80-year-old member of the court, and a 78-year-old member of the court. And so I think that no one thinks that whoever the next president is will go a whole term without having another chance to fill a vacancy.
There's one doomsday scenario that anyone who loves the court doesn't want to see, and that is that the Senate actually does what Senator McCain talked about on the radio and then kind of took back, and that is the Senate stays Republican, and they just play out their, and Secretary Clinton becomes President Clinton, and the Senate just plays out its hand. It keeps that seat unfilled for as long as it can. My sense is that we've been in a kind of slow boil constitutional crisis since the Senate Republicans refused to consider the Garland nomination, but it would go to a high boil, and it would be so terrible for the court and so terrible for American politics, and that's not an impossible scenario.
It's also just a terrible precedent that the Senate Republican leaders have set now. It's almost a form of blackmail that any time a president is how many months in still to run yet in his last or her last year in office, that you can block a nominee this way. So the Republicans do it this time. Well, maybe the Democrats will want to do it the next time. And we just it's just really very sad.
All right. So here's another one. Will Justice Ginsburg retire after the election?
Well, I think that's an easy one. Yes.
I once had a colleague who predicted Justice Blackmun's retirement every year for 5 years, and he got it right finally.
I will say I wrote a column not too long ago saying, don't schedule the moving bans yet, because for one thing, she has already picked the clerks that would be working for her through June 2018. And if Secretary Clinton wins, if there is another Democratic appointee to the court, another liberal, for the first time, Justice Ginsburg would be the senior justice among 5 liberal justices. And that means that when the court makes a decision, when only those 5 are in the majority, she either gets to write the opinion herself or decides who gets to write the opinion. And that's a power that she's never had before. And I think she'd want to use it for a little bit before she decides to retire.
All right. So Justice Breyer has noted that most cases are not 5-4 decisions, thus we shouldn't worry so much. What are your thoughts about that?
Well, he's absolutely right. I mean, we tend to forget that there is a considerable amount of consensus across this court, which is ideologically divided. If you count, say, 8-1, when they had 9 justices, 8-1 decisions or 7-2, you're looking at, almost 60% of the court's docket, and that's pretty good, I think. So. But for me, and I think my colleagues, the 5-4 decisions, well, one, they often come, but not always, but often come in the cases that raise the most difficult questions that people care the most about. And for someone who covers the court like me, where I learn the most about the individual justices. So you almost have to go back and look at all the 5-4 cases for the last, say, 11 years, and you probably would see that those 5-4 those cases are dominated not by your blockbusters, but they're dominated by, say, death penalty cases involving habeas corpus and the ins and outs of habeas corpus, which is just a really difficult area of the law. I think, I don't think Justice Breyer should say, "Don't worry about them," or as he would say, "Don't worry about them." So I think there's some truth to what he says, basically.
I also think that he worries about it more than he lets on. Justice Breyer's most eloquent opinions have been dissents.
Yes.
Starting in 2007 with the parents involved voluntary school busing case that was at its heart a case about race. And he was so upset by the ruling, which had the conservative majority striking down these voluntary plans in Louisville, Kentucky, and Seattle, Washington, that when he read his dissent from the bench, he added a line about how never had there been so much change so quickly, really because of one change on the court. But there are other dissents that are just as important. His dissent in a case about contracts enforcing arbitration on consumers was an elegant one and pushed back against the corporation favoring Roberts Court conservative majority. In the McCutcheon case about campaign finance, he was also eloquent and really took on this issue of the meaning of the First Amendment. And he's done this so much that's really evidence against his civic-oriented description of the court being occasionally divided but mostly unanimous. And in this case, I think you have to watch what he does as much as listen to what he says.
All right. Should nominees for the Supreme Court always be judges or even lawyers?
Well, I think they should be lawyers. It is not, it's not a requirement for the job, but I once heard, there's an area of the law called ERISA, which is about retirement, and it's really mind-numbing. And Justice Scalia once said, whenever I hear this, I think, do you know how many ERISA cases we hear? Only a lawyer would do that. But no, I don't think that they have to be judges by any stretch of the imagination. We have one member of the court now who was not a judge, Elena Kagan. I think when you read her opinions, or if you watched her on the bench, you would have no idea that she was different from the others in either her understanding of the law or the way she writes. In fact, I think most of us would say she writes some of the clearest and most accessible opinions. And I don't know that's because she wasn't a judge, but certainly it just shows that that it's not a prerequisite for the job. I do think it would be interesting. The presidents always talk about, I'm going to do something different and I'm going to find someone, and then they end up nominating judges. And I think partly because it would be hard for a politician to get through the nomination process now, because that person would have taken stands on so many controversial issues. And I think also because they don't want to nominate surprises anymore. We've talked about how the justices that they appoint, the most recent ones, really have done pretty much exactly what the president who appointed them had hoped that he or she would do. And I think judges, especially appellate judges, have long track records for the president to look at before making these nominations.
Right. What would the Roberts Court do with a 2016 version of Bush v. Gore?
So the tricky part of that is that when Justice Ginsburg sounded off about Mr. Trump as a candidate for president, she clearly was in violation of the standard articulated in the code of conduct that applies to all federal judges, but not to justices. And so technically, it wasn't a violation of legal ethics for her to do that, because she wasn't bound by that. And on the other hand, she proved that she was at least, in that instance, the exception to the rule that the Chief Justice had articulated when he said, we don't need to be bound by the code because all of us follow it. I think that a lot of us would feel that she would have to recuse herself if there were a Bush v. Gore kind of outcome because of that statement. And if she didn't, that it would make Bush v. Gore look like a mild controversy however the court decided. But I'm really hoping that the alert that Mr. Trump has put every Secretary of State around the country on to make sure that the process of election goes smoothly throughout the country, that it will lead to an outcome that makes for no lawsuits or lawsuits that are quickly considered frivolous given the outcome. We'll see.
Agreed.
All right, we will end on this final question. One more on Merrick Garland. If confirmed, which recent justice would Merrick Garland most resemble?
I would think Breyer, except maybe in the criminal area. There, I think Judge Garland reflects his background as a Justice Department prosecutor, and based on, the DC Circuit doesn't get a lot of criminal cases, but based on what he has done there, that's the one area where he has shown himself to be more conservative than moderate. So, but I think he and Justice Breyer would enjoy each other.
Judge Garland is brilliant and hardworking and personally modest and punctilious in his writing for the DC Circuit. He's also a minimalist, which is to say he believes that the job of a court of appeals is to decide the question before the court and not a broader policy issue. Now, being a justice of the Supreme Court is different from being a federal appellate judge. As one former Solicitor General said, the job of those judges is to salute the Supreme Court. And the Supreme Court doesn't have to salute itself. But I think it's right that he would approach the work similarly to Breyer, though their interests and the way they write and in many other ways they're quite different. Their priors, as Judge Richard Posner calls them, are different, and that would show in their opinions.
I think you saw our hesitation, though, in that I think it takes a while for a justice to reveal himself or herself. I don't remember who said it, but the great line was that a justice spends the first 5 years wondering, how did I get here, and the rest of the time wondering, how did the rest of these people get here? But I think that it does take a while for them to get comfortable and to get past that idea of, I used to have something else to look to decide these cases, and now it's sort of on me to do it. And so I think it's a little hard at this point, but I agree that from what we know of him now, that seems to be the justice he would most be like.
Excellent. Well, Marcia, Link, Bob, thanks so much for joining us. Please give them a hand. Thanks for a great conversation.
Thank you. Thank you.
Oh, thank you. Thank you, Link. Thanks, Bob.
Thank you.
All right. I think we escaped that way back to the green room.
Thank you.